Hi everyone. This is part 2 of the Evolution of Human Rights Law in Ontario and Canada PowerPoint presentation. You'll remember that we finished off part 1 of this presentation last week, talking about the Canada Fair Employment Practices Law that was passed in 1953. So this was sort of the earliest version of the laws that we have today that work around equity in the workplace. If you were paying attention, you noticed that in the Road Taken video, Lee Williams went to the Brotherhood of Railroad Employees Union Convention in 1955 to try and talk them into taking the racially discriminatory language out of their contract, out of their collective agreement. And he was voted down. This is one of the problems with democracy, is sometimes it is not awesome at valuing the needs and rights of minorities. So what ended up happening is Lee Williams and the Sleeping Car Porters Union spoke to the federal government, and the federal government, under the Canada Fair Employment Practices Act, told the railroads and the union that they had to stop practicing discrimination in their hiring policies. Right? So that's where we left off last week. Let's see where we're at now. So the next year, so the Canada Fair Employment Practices Act was passed in 1953. And then in 1954, Ontario introduced the Fair Accommodations Practices Act to end racist discrimination in the delivery of services and accommodations. So by services, we mean things like restaurants, car washes, libraries, public pools, that kind of thing. Okay, so the Fair Accommodations Practices Act said that no one can deny to any person or class of persons the accommodation, services, or facilities usually available to members of the public. Right? So if you're going to serve one group of people, you have to serve everyone. Other provinces shortly followed Ontario's lead in passing similar laws. Now, when you watch the video for this module, you will hear about Hugh Burnett and McKay's Cafe in Dresden, and he was denied service. And in the movie, in Journey to Justice, Ruth Laura and Bromley Armstrong talk about going to McKay's Cafe with a reporter after the Ontario Fair Accommodations Practices Act was passed and waiting to be discriminated against by being denied service, so that then Laura and Armstrong could file a complaint under the Fair Accommodation Practices Act. So one of the things that I hope you're noticing is that these laws are complaints-based. Okay, so this is one of the criticisms still of human rights law in Canada. So with health and safety, law, you have inspectors who go around, right? So for example, restaurants, right? They have inspectors that come by and make sure that the restaurant is abiding by health and safety law. And if the restaurant isn't abiding by health and safety law, the inspector has the power to close the restaurant down, to fine them, to order them to fix things, or they'll be closed down, etc. But with human rights law, so far, there are no inspectors. So there's no one who goes around to workplaces and makes sure that, for example, at a restaurant, the employer hasn't put all the brown people in the kitchen and all the white people serving out on the floor, right? So because this is complaint-based, the onus is on the person who's been discriminated against. And that can be a bit difficult, especially if that person doesn't have a lot of money or time, because human rights complaints or a complaint under the Fair Accommodation Practices Act in the 1950s and 60s, they take time and energy, and often you need some kind of legal advice, which costs money. Okay. So 1954, Fair Accommodation Practices Act, and you'll hear about how that act was applied in the video. In 1960, Canada, so the federal government now, passed the Canadian Bill of Rights. So in the 50s, it was clear that Canadians wanted some kind of version of the Universal Declaration of Human Rights in our law. Okay, so many called for a Bill of Rights to be added to the British North America Act, which is our constitution, right? But all attempts to agree on amending the British North America Act ended in failure. So you need pretty much unanimous agreement to amend the constitution because it's so important. So conflicts between the various provinces concerning property, language, criminal law, and religion made reaching a consensus around what a sort of human rights law federally should look like difficult. So in the end, Prime Minister John Diefenbaker was frustrated by the squabbling between the provinces, and he unilaterally adopted this law, the Canadian Bill of Rights, in 1960. So it's kind of the predecessor to the human rights laws that we have today. In Ontario, the Ontario Human Rights Commission, which is an organization, a government organization, was created in 1961 to administer our human rights law, which is the Ontario Human Rights Code. Things have been added to the Human Rights Code since the 60s. So, for example, my people spent a lot of time agitating to have sexual orientation added to the Human Rights Code, and it was in the 1980s. So the Human Rights Code is a provincial law that gives everyone equal rights and opportunities without discrimination in specific areas such as jobs, housing, and services. The code's goal is to prevent discrimination and harassment because of the grounds. So they call these the grounds of discrimination. So grounds include things like race, color, sex, disability, religion, age, and sexual orientation. Also recently, gender identity and gender expression have been added. The code was one of the first laws of its kind in Canada, and other provinces quickly followed Ontario's example in creating their own human rights codes. So human rights laws are super important, and Canada has a lot more protections than many countries. But as I was saying, there are still some problems. All right. So the Ontario Human Rights Code does not have inspectors. So there's no kind of government funded enforcement of human rights law. If you think your human rights are being violated in Ontario, you have to file a complaint with the Human Rights Commission. That's what the commission is for, right? They administer the code. Filing a complaint can be time consuming. It can be intimidating, especially if you don't like paperwork, right? And it can be expensive, especially if you need to hire a lawyer. Critics point out that this kind of law, the complaints-based law, require the person who's facing discrimination to do a lot of work to get their rights acknowledged. And some people, especially some of the people that we've been talking about, like non-status immigrants or brand new Canadians, might be too afraid or too busy earning a living to use these laws or to complain, right, to file a complaint. Human rights protections could be made much stronger with a system of inspection and enforcement. The federal government passed the Canadian Human Rights Act in 1977. So this was an updated version of the 1960 law. And in doing so, the Canadian government joined 9 provinces in creating one single law to deal with discrimination. The act also set up the Canadian Human Rights Commission to administer this law and to ensure compliance. Now, the really important part of federal law around human rights is the Canadian Charter of Rights and Freedoms. In 1982, the Canadian Charter of Rights and Freedoms was enacted as part of the Constitution Act. Right? So this is what Diefenbaker was trying to do, but Pierre Trudeau is actually the one who managed to do it. Because the Charter is part of the Constitution of Canada, it is one of the strongest laws that we have. It's very difficult for politicians or other folks to ignore. The Charter guarantees Canadians fundamental freedoms, democratic rights, language rights, mobility rights, minority language education rights, legal rights, and equality rights. And I've included the link there if you want to find out more about the Charter. But the Charter is kind of Canada's pride and joy when it comes to human rights law. The only other country that I know of, there might be one I don't know about, to have human rights law in their constitution is South Africa. And they did that partly modeling on what Canada had done. So finally, it's important to understand the human rights protections that we have here in Canada are the result of a lot of regular people demanding and working for change. So the people who you meet or met in the video Journey to Justice, like Hugh Burnett, right, like Viola Desmond, like Stanley Grizel, and others, spent many years of their lives attending meetings, writing letters, making speeches, going to see government representatives, filing claims in court, talking to reporters, making complaints, marching in the streets, and much more. Donald Willard Moore, who you also meet in the video, and others went to see the Minister of Immigration about the racist immigration laws in 1954. And it is not an accident that by 1962, most of these racist rules were dropped. And then in 1968, the merit point system was adopted. And if you don't remember all the details about that, you can read about them in the ESIDU reading, right? So often, one of the best ways to sort of gauge social things is to look like in decades. All right, so all these activists organized and did an incredible amount of work in the 50s, and then by the 60s you have the government responding by getting rid of racist laws, by changing laws so that they're attempting to make them racially blind. They're not always, but at least there are attempts. Right, so these activists, the work that they did, the things that they dedicated their lives to, it paid off. Right, it doesn't always pay off immediately. That's not how societies work, but it does pay off. So I want you folks to remember that we owe these activists for the laws that we have today, right? They are our ancestors, and they did this amazing work for us, right? Now, the other thing that we owe is to remain vigilant and to remain active, to make sure that these laws that we have don't get sort of wiggled around, don't get overturned, don't get taken away, right? So one of the things that Prime Minister Harper did when he was Prime Minister was he took away all the funding that gave people money if they were poor so that they could make charter challenges. So we need to be pushing politicians to do things like put that fund back so that if people want to make charter challenges, there's funding available for them. So it's up to us to make sure that governments don't roll back the laws that these activists work so hard to get us. Okay, so make sure you filled in your form and that you have notes about all of these laws because they will come in handy as we go. All right, thanks and bye.